you, Mr. Roberts.
Justices, I'm for the second and third respondents. While I'm on my feet, may I ask if my learned friends consent to hand up a short supplementary affidavit?
So, I don't have any affidavit from the second or third respondent.
My Lord, that is surprising. They worded it yesterday. Bear with me for a moment. Bundle as item 8 and item 9 at pages 258 and 268 according to the image provided by the applicant. An affidavit by the second respondent.
Oh, yes.
And that's 2 to 6 pages affidavit by the speaker, Mr. Jacob Edward Smith.
Yes, we've seen those. Sorry, they weren't filed under a particular filing sheet, so once attention wasn't drawn, I'd assumed that they were part of the replying papers.
Notice is that item 4 on page 181.
Fourth respondent.
181.
No, the 181 is for the fourth respondent. It's a duplication of an earlier page.
Well, that's unfortunately a pagination error. May I ask you then to hand up a copy of that notice?
Would you mark it as... (182) capital A. And 182B.
This one is yours. Now for your lordship's brother, hand up my copy as well, so that we have a copy.
And the affidavit that you handed up earlier, Mr. Breitenbach, will go in. Where would you like to put that in? Inserted at an appropriate place before the replying affidavit?
All right.
No, I prefer to put it chronologically, perhaps at the end of, after Mr. Smith's affidavit.
Yes. That would then be at page 275, capital A.
Certainly. 275. A, B, and C.
Questions from you guys, that will be the extent of my contribution today.
Mr. Breitenbach, so what is the attitude of the city manager in the city? Very well. Any of the other parties have any difficulty with the filing of these late papers? No problems? Just to repeat on the record what council were informed in chambers, the Judge President has directed that the Part B relief in this matter be heard by a full bench of 3 judges of this division in 2 weeks' time on Friday the 25th of May. So as I understand it, all of the parties are agreeable to the relief sought in paragraph 2.3 of the notice of motion. And that relief will be granted together with the postponement of the matter until the 25th of Mayor. What remains then is the question of interim relief.
For the sake of recordal of this affidavit that is just being done now, by Mr. President, that what it says essentially is something that might be relevant as we go along, namely that the allegation that the makeup of mayoral committee had already been appointed was incorrectly made by mistake. In other words, as we sit here, there's no mayoral committee, despite what Mr. South says in his affidavit.
So, is the position then that the position of mayor is currently filled by the deputy mayor, as in an acting capacity?
Filled, well, in our version, it's not really properly filled, but yes, there is an acting mayor, face value at least.
Mr. Nielsen, is it?
Mr. Nielsen, correct, fellow. And the allegation in Mr. South's affidavit was that he had conferred or appointing a mayor, which is now just incorrect.
So, there are no new members of MACO appointed, and in terms of the DA's understanding of it, the existing MACO was dissolved with the termination of the membership of your client.
Well, that's an interesting question. Whether it would have been dissolved by the termination or dissolved by the appointment of the new mayor. But I don't think that's a question that we need to...
Well, it is an important point from the balance of convenience point of view, because the argument that's put up is that the city will have an old MACO, a new MACO, and then another MACO. If the parties could inform us as to whether a practical arrangement could be achieved in that regard, I suppose it rests really with Mr. Rosenberg and his side. That may assist us in determining the matter.
I propose that to save time, we can do that during one of the breaks.
Yes.
And then we'll inform the courts.
Yes.
Yes, sir.
Yes, I had in mind sitting till about 11:30 to take a short break. If you could finish in an hour, we'd appreciate it, because this is the fast track of the urgent court today. There are other matters. While you're on your feet, Mr. Mpofu, we note from the papers that neither party takes the point of urgency.
Yes.
That may be because it's expedient for both parties to have the matter determined today. But the provisions of Rule 65G are quite clear. An applicant for urgent relief has to make out a case for urgency, and she has to allege, in terms of 65G, it's obligatory, she has to allege that she will not be able to get effective relief in due course. I do not see any such allegation in the applicant's papers, but I leave it to you to deal with at your discretion. Thank you.
Yes. Firstly, I'll start where the contest started, namely that it would seem, subject to what my learned friends have to say, it would seem that the question of urgency is not an issue considered or at least taken for granted, judging the answering of David.
The question of urgency in this particular matter presents itself in a slightly different form. The points taken on behalf of the first respondent, the lordships will receive. The first respondent's contention is that obtaining interim relief at this stage is an inappropriate remedy. The proper and available remedy is a review court on abbreviated time. So in a sense, that is dealing with the need to hear the matter for relief today, on the assumption, on the contention that in fact relief in the immediate short term is neither necessary or appropriate. So that also goes to the question.
Thank you. Mr. Mpofu?
Well, I don't think I understand what that means. My understanding from what they say in their papers is that because the matter is urgent, they were prepared to have it heard within a short space of 2 weeks, which now has been taken care of by what the court has informed us. And for that same reason, they did not take the court of urgency. But for what it's worth, it doesn't look like there's going to be a debate on urgency per se. But as to whether the necessary amendments have sufficiently been made, I will deal with it maybe towards the end of my argument, if it's still necessary. But now, what I wanted to say by way of housekeeping at this stage is that my learned friend and junior, Mr. Duval, we're going to split the presentation, and I have asked him to go first, because part of what he's going to cover is the factual background, which he has been engaged with for the past 6 months. The second issue that I need to deal with, and the factual background anyway, is important in this matter for various reasons. One, because it is part of the interpretation issue, which I will deal with, but also just to familiarize the court. The second issue is the issue of what the other side is calling their heads technical non-compliance, or what we prefer to call jurisdictional facts, the absence of jurisdictional facts for the application of the relevant rule of the DA Constitution. Mr. Duval will expand a bit on that. And then, either separately or as part of the factual background, Mr. Duval will also deal with what we might call a shorthand, the Makeza interview, the radio interview that brought us all here.
Yes, I think it was said in the, I'm going to refer to the parties by their names, but in the DA's papers that there's a transcript of the Makaiza interview available. We were given a link to the, what do they call it, podcast. I've listened to it, my colleague hasn't. And I think we would both prefer to have full transcript of that interview, if it's available in 2 copies.
Yes, I'm sure it is. If it's not through the arranged, we would also appreciate it.
Thank you.
Then what I will do with, I will start with dealing with the preliminary point about horses voted and all that. The submission that Mr. Rosenberg was alluding to now about the appropriateness of intermediate in the first place. Then I'll deal briefly with the interpretation, proper interpretation to be placed on the Makaiza interview. And then the real issue that of substance, the constitutional and legal grounds for this application. And with the permission of the court, I prefer to do that under the rubric of the requirements for interdict. In other words, I'll put in whatever constitutional issues in that.
Yes, you're welcome to choose whatever course you wish.
But before I hand over again to Mr. Duval, I'd just like to maybe signpost where we're going. By simply saying that the facts of this matter are deceptively simple, that actually there are serious questions of principle, policy, and constitutional law that underlie the matter. But of course, no doubt, in 2 weeks' time, those issues will be fully ventilated before the full bench, as it has been kindly indicated. And those facts really go around this simple question. Given the constitutional context and everything that we will talk about, or that has been alluded to in the papers, can the words used by Ms. de Lille in the Makeza interview on the 26th of April really justify her hurried removal on the 8th of May 2018? That's really it. It's all going to be an answer to that question.
The interview was on the 25th.
26th, my lord. 26th April, the utterance, the actual utterance. And the removal, purported removal or cessation of membership, 8 May. Now, that's what sounds like a very simple matter or question to answer. Until, of course, we realize that purported removal does the following three things. It removes her from the membership of her chosen political party, which, as I will explain later, deals with the rights which are enshrined in Section 19 of the Constitution of all citizens to choose a political party of their choice, or rather to join a political party of their choice. So that's the first thing it does. The second thing that it does is to take her from the position of a councillor, to which she has been democratically elected by the citizens of Cape Town. And that then basically brings the interests of each and every citizen of Cape Town into the picture. And the third thing that it does is to remove her from her governmental position of mayor of the city of Cape Town, to which she was duly elected by the council, not by her party, but by the council as a whole. And I will expand on those issues when I do my section. The last point, by way of signposting, that I really want to make, Justices, is that, and that will link up with what my learned friend Mr. Duval will outline as the history of this matter, is that, as a matter of principle, the applicant is here to seek justice. And in seeking justice, she symbolizes what we say to everyone, that you must, whenever you are in this kind of situation, resort to the courts. Don't resort to self-help or other methods which might offend the law. Now, it does not matter what we might think of the current situation in the city, or the position of the mayor, or this particular mayor. The issue is what does the law compel us to do? The goddess of justice is blind for a particular reason, or so-called lady justice. So we can't have some rules for Ms. de Lille and other rules for another mayor that we may or may not like. And I always make this point more graphically by saying, using the examples of the presidents. We can't have certain rules for Nelson Mandela and other rules for Jacob Zuma, for example. Whatever our views are on those two gentlemen. And I think that makes the point clear. And in order to preserve these things, you know, we come from a particular history where it was easy to make rules for certain people because they are black and others because they are white. And to undo that, we designed something called the Constitution. And the Constitution is there to be a bulwark to make sure that we apply justice blindly. And I'm saying this because the main thesis of our submissions is going to be that what has happened here in the past 10 days or so is really an insult to the intelligence of this court and the intelligence of the citizens of Cape Town, if not the country. Because it's merely a subterfuge which was designed to achieve that which could not be achieved by lawful means. And Mr. Duval will take you through the sordid history of this matter. But for my purposes now, I simply want to say that it's very clear that what happened is that the city had three options to do this. The first one was to do it lawfully by putting the motion of no confidence in the mayor before the city council. They did not take that option because it was taken before and it failed dismally. The second option that they had, where the illegality starts to border now, was to apply the so-called recall clause, or as we call it, the de Lille clause, in respect of which, simply by having the caucus or the party deciding that she must go, then she can be the court. We sent them our papers as a matter of courtesy to indicate that that particular effort was going to be challenged very vigorously, because that clause is plainly unconstitutional. So the third option was then...
Is the litigation pending in relation to the recall clause? Has that been initiated?
No, it was overtaken by events. That's exactly what happened. While purportedly the party was still taking legal advice on the forthcoming challenge, then this came into play. Now, this is very important, my lord. You might interpose whatever I would say is plan. So if plan A would have been to go to the council, maybe plan A2 would be to return to the council, and I use the word return advisedly. In other words, despite the fact that the motion might have failed in February, they could have gone back to it now, after they received our papers.
So, you were also calculating these options?
Yes, I'm still there.
Oh, you're still there?
Yes. I'm kind of interposing a third option. Yeah. Remember, my lord, I said that the first one would have been the original one.
Yes.
Second one would have been the recall clause. I'm now saying the third one would have been a return to the council. Except, if you look at the papers, then you'll see why they did not return. It's very simple. They had, in fact, there's, in most cases you don't get this. There's what one might call a smoking gun. It's at page 262 of the papers, where effectively Mr. Smith, who's the ringleader of the other side, explains to Mr. James Self, who seems to be the embodiment of the party, that the caucus there today, that is 16th of April, felt that it should test, I'm sorry, I'm reading the last sentence of the first paragraph. 262, I hope there's no mix-up with the pagination. It should be an email should be an email from Jean-Pierre Smith. You can just take it back, see that we're on the same page. All right. I don't have to go to it now. I'll just paraphrase what I'm just situating. In fact, it looks like there's a problem with continuation. In any event, what I'm saying, Justice, is that in that email, the words.
I'm sorry, you get that.
Yeah, 247.
Yes.
That's correct. 247. I apologize. The first sentence of the email, I'm just reading the words. The caucus today felt that it should test the confidence in the mayor within the Cape Town DA caucus. In other words, there was now an attempt to return to the council. Except, of course, we now know that when that vote took place within the caucus, 97 councillors, 97 DA councillors voted in favor of it, and 41 voted against it, 41. What's the significance of that?
Sorry, just remind us, when was the recall clause
Promulgated.
On
the 7th and 8th. The conference was on the 7th and 8th of April. 7th and 8th of April.
This is about a week later.
Literally a week later, it's being applied, and people wonder why it's called the delay clause. Now, what then happened there, it's very interesting, because we had this split 97 for, 41 against. Now, what that means is exactly this. Remember, the magic number is 116, because the councillors are 221. So you must pass 116, because there are 77 opposition members in total. So if you put 77. Now, if you put the 77 opposition members and the 41, you get exactly 118. If you remove Ms. de Lille from the picture for a minute, then you get 117, which means she would win the vote by one vote again. Which is exactly, so that option was not taken because it would have come to exactly the same outcome. Probably this time she would win by 2 votes because she would vote this time. She might. That's really why we're here. So now you're faced with this. The clause is unlawful. You can't go back to the council. So what do? You must trim up some fuss and some subterfuge to get rid of her.
Why do you say the clause is unlawful?
The recall clause, I've already covered that.
It hasn't worked.
No. As I said, we serve the papers on them as a matter of courtesy, showing the grounds upon which the recall clause is unconstitutional. Right? What then happened, my Lord, is that on the 4th or 5th of May, they came back to us and said, we're taking legal advice on what you have said in your papers.
Could I just ask you to stop for a moment there?
Yes.
It appears from the papers that a copy of intended court papers was served on the party sometime towards the end of last week.
Yes.
Thursday, on Friday or Saturday last week.
Yes.
And then they said they're taking legal advice. Are these the papers? Is it the founding affidavit in this matter that was served on them, or some other document?
No, of course not, my Lord, because remember at that time it couldn't be these papers because the, what do you call it, this clause,
The recall clause.
automatic cessation clause had not been invoked. So in reality, it's an adaptation of those papers, but obviously taking into account what had happened on the 8th, yes. So that's the background. So everything you're going to hear then is...
The draft papers were intended to be an attack on the
recall clause.
On the recall clause.
That's correct, Alan. That's correct. Because at that stage, that was the only... By the way, that also raises another interesting question, which will probably be ventilated fully in Part B. Namely, whether the same party can, at the same time, they've received the so-called complaint on the 2nd, on their version. And then on the 4th and 5th, they tell us that they are taking legal advice on the recall clause. Have they not waived their right to enforce the so-called automatic cessation clause if they've conducted themselves as if they are pursuing the recall clause? But all those interesting matters will be dealt with in Part B. The only point I really want to make is that everything you're going to hear today is therefore the conduct of the DA in the pursuance of this, what I call subterfuge, given the fact that all the proper legal avenues are closed, to just simply impose an unlawful mechanism to achieve the ends. And on that note, I will ask my learned friend, Mr. Duval, to take the court very briefly through the history of the matter and put those issues into perspective. Yes, thank you.
Lords, just one qualification on what the leader said. I haven't been involved for 6 months only. I sometimes wish that was the case. It's more than 14 months because, as I will explain very briefly, the history go back further. Lord, I would like to spend 10 or 15 minutes at most on the background and just highlight a few phases for the purpose that Mr. Porf was already submitted to you. If one looks at the background, it is clear that the cessation clause was an option of last resort. It was used when the disciplinary process was perceived to have been driven into the sand by us complaining about the panel wanting to have underlying documents such as SMSs and so on. It was used when the motion of no confidence in council failed on 15 February this year, and when it became clear after this Congress that it will fail again, it reinstituted. It was used after we served those draft papers on 4 May on the party dealing with a recall clause. And the argument was made, you cannot usurp the functions of the council by adopting internally for the party a recall clause and say that if the majority of DA councillors, not the majority of councillors in the city's council, but the majority of DA councillors decide we've lost confidence, then you de facto lose your membership of the party, which means that you lose the position of councillor. It is then in those circumstances that we submit that the clause that was ultimately invoked, section clause 3.5.1.2, was not invoked in a bona fide manner, and the discretion conferred by the clause was not exercised boni vire. I know that the DA says that there's no discretion, but we will show your lordships that there is certainly a discretion as to whether one wants to invoke this vague and general clause. And As any unilateral contractual discretion or right, it must be exercised boni vire. That's the one reason why the history, boni vire, my lord, as a reasonable person would. That's the one reason why we need to spend 10 minutes or 15 minutes on the history or the background. And the second one is, if one looks at what happened over the last 12 months, the DA cannot contend today that any harm would result if the mayor stays in her position. If the notice that they gave or the certification of the cessation clause is suspended for a period of 2 weeks, there will be no harm to the DA. There will in fact be no harm to the city. It's not for the DA to, of course, contend that there's harm to the city. It's for the city to say that. The city isn't saying. So it affects the balance of convenience argument, which Mr. Mpofu will deal with. Because if you look at the history, it shows that there's not even an allegation of serious wrongdoing made against my client, our client, let alone a finding of any seriousness. It would have been different, perhaps, if the DA could contend this is a woman, a mayor, which has gone rogue and is corrupt or has been captured or something like that. But we know from the history that that is not what the situation is. There's never been an allegation that she's a mayor that's so bad, so corrupt, so captured, whatever the case may be, that she cannot stay on for that reason, let alone stay on for 2 weeks. Now, I will just highlight with reference to dates. Unfortunately, we didn't do a chronology. We may, if your lordship would like to have a chronology, compile one over lunchtime.
I don't think it's necessary at this stage. Maybe preferable in 2 weeks' time. At the moment, we're dealing with whether we should be I think you can attenuate your rest
as a court pleases. Lord, the background starts in January, February in 2017. This is the run-up to the provincial election for the new DA provincial leader. And we've highlighted there, this is the first time a complaint comes from the DA and where Mr. Lille started his case. Sorry, my lord.
Date again?
January, February 2017. That is what we call on the papers the Joshua Dan saga. This is the first time that the DA wants to act in a disciplinary way against Mr. Lille, and that is in the context of Mr. August and Mr. Kempthorne, Mr. August in particular, running for provincial leader. Now,
when was the provincial congress?
25 February. It was in February, 25 February, if I'm correct, in 2017. And the argument is that she leaked a party document which basically outlines how you should get approval for expenditure. And the argument is that that contravenes somehow the DA's constitution, etc. But it takes place in the context where the report runs a front page article about the findings made against Mr. August that was running, perceived to be aligned to Mr. Lille, against Mr. Makizela. It is in that context where the first disciplinary charges start. I mean, they leave it at that. Those charges are eventually not pursued. Next, we're dealing with the appointment of Mr. Steenhuisen in June 2017. Mr. Steenhuisen was appointed.
Was there a leadership change at the
Yes.
provincial level at that time?
She resigned as provincial leader in the beginning of 2017, as I had.
So are you suggesting that the first DC was somehow linked to a leadership struggle.
Yes. My Lord, we haven't described that part of the history in detail in the papers, and that's why I'm not dealing with it. It's described in great detail in the Steenhuisen papers, what happened with this bizarre situation that a week before the provincial leadership enlisted, Mr. Gottsel tried to organize a meeting with Mr. Lille, and she then says, I'm not available, I can only see you next week. And he says, no, that will then be moot, because the leadership election is over the weekend. I need to come there before the election.
So the one I'm saying, first disciplinary was abandoned.
Yes. Then we go into June 2017 when the Steenhuisen committee was appointed. And that committee
June 2017, Steenhuisen what?
The Steenhuisen committee was appointed, my lords. The committee was appointed to resolve tensions in the caucus of the City of Cape Town, the DA caucus. However, as we contend in another court case, the other court case pending before this court, Steenhuisen went way beyond his mandate, and he then made a series of findings against Mr. Lille. The entire report consists almost exclusively of findings against Mr. Lille. Some of them quite strange. For example, he finds that she somehow now took away the right of sub-councils to decide on planning matters. But of course, we know that the legislation changed, and it's actually the municipal planning bylaw and Spluma and Lupa that changed that. Anyway.
May I just flag one issue? I have sat listening to the submission. I would, in your lordship, will notice this, point out that a significant proportion of what is being put up before your lordship is not on the papers and remarks to council effectively giving evidence in relation to the matter. I'm flagging that.
Your objection is carry on to the papers.
Yes.
Not to your personal representation.
My lords, but there are two disciplinary charges which emerge from Steenhuisen's report, ultimately finalized on 10 December 2017, and the mountain then gave birth to 2 mice in the form of disciplinary charges. Number 1.
Mountain, there's 2 mice.
Waar het de muis gebaar? Ja, moet. This is pension. The Steenhuisen committee, having listened to evidence from councillors and DA members, came up ultimately with a series of findings against Mr. Lille, but it only recommended that 2 disciplinary charges be instituted, and the one is an SMS that she sent, allegedly sent, in respect of the scoring of Mr. Ahmed Ibrahim, who was then a candidate for the position of municipal manager. Yes. Okay, my Lord, maybe I should just broadly describe some of the papers. The SMS is certainly on the papers, my Lord, in respect of, but we've been trying to get the SMS, as you know, and for the last perhaps 7 months. My Lord, may I then just park that issue? But there were two, by way of background, it produced these two charges.
There's been a fair objection to the fact that we're not sticking to the papers. We're sitting as an urgent group, and
Yes.
we have a lot of submissions there. Please just keep your argument focused on the papers, because we have to deal with it afterwards when we consider judgment.
Yeah, my Lord, at page 21.
Thank you.
I supposedly sent this SMS regarding the scoring of Mr. Ahmed Ibrahim in the title position of city manager. So,
Page 31,
21,
paragraph.
paragraph 31.6.
Thank you.
Lord, I'm going to cut this short and provide you the background in broad strokes. There was an initial attempt in the context of provincial elections. Then there was the Steenhuisen Committee that was supposed to resolve the tensions. Steenhuisen brought out a report on 10 December 2017 in which he made some findings, including findings such as the SMS, which then were referred to the FLC ultimately for disciplinary charges to be brought against Mr. Law.
Did the Moorman DC then, was that constituted to deal with the Ibrahim SMS?
Yes. Inter alia. It started with the SMS. But then further charges were added. Because the Bowman's report was then, you would have seen from the papers, my Lord, that the Bowman's report from page 23 onwards, the Bowman's report came out at the end of December 2017, and these charges were then added from page 23 onwards. What they really involve is, again, allegations which we describe as very technical, certainly not the kind of allegations which would mean that the city would be harmed if my client were to remain in a position for 2 weeks. What Bowman's did was...
Did the Bowman's report lead to a new DC, or were those charges added to the normal DC?
Added to normal. In respect of Mr. Lowe, Bowman's made recommendations or were investigating, still is investigating, two aspects. The Volvo bus chassis were paid for before the whole bus was received. So basically the city decided, in order to spend capital, it wanted to pay for the buses, the bus chassis as they were completed before the whole bus was delivered. Ms. Whitehead was then held accountable for this or responsible for this. Bowman's then recommended that she be referred to the City Council for investigations. And it's alleged that my client stopped that or tried to interfere with it. Not that she's got the power to refer Ms. Whitehead to the council. Mr. Ibrahim always had that power. Then the City Foreshore project. But again, these are not the kind of charges which would, we stress, even included, ultimately, necessarily result in Mr. Lowell being found to be corrupt in any way or incapable of proceeding. So these other charges were then added. By 15 February, however, 15 February this year, you would have seen from the papers, under the heading, Motion of No Confidence, you would have seen that then there was an attempt by the DA to bring a motion of no confidence in council against Mr. Lowell. And that's the motion that my learned friend has already referred to, which then failed with one vote.
What were the numbers there?
So, my note, page
What were
16.
the numbers in the confidence vote?
I think it was 109 versus 108 today.
What is the vote?
Yeah, it was 109 and 108 thereabouts.
110. 110, 109.
110 and 109.
Does that's so if it failed by one vote, does that split suggest that some members of the DA caucus would have voted against the motion of no?
No, definitely.
Sorry, some in favour of it and some against it.
Absolutely. The debate in the previous case when we were here, which resulted in the judgment of Mr. Justice Henry, was exactly about how the vote should take place so that DA councillors would feel free to vote against the motion. And in the end, the Speaker ruled that there should be an open vote, but nevertheless it failed. So just coming back to the broad strokes again, Steenhuisen's report resulted in disciplinary proceedings and they were then added after Bowman's. By 15 February, however, there was a motion of no confidence this year, which failed. Right after that motion, the Moorman DC starts. Or there's some pressure on us to agree timelines in order for the Moorman DC to start. There was from the beginning a demand from Mr. Lille that that hearing be one open and two before an independent person, an outsider, impartial and independent third party such as a retired judge, I believe there are many in Cape Town, or a senior advocate. And it is really those two demands of hers which have led to the disciplinary proceedings stalled, because when they were not conceded to, she took objections about the composition of the panel, the involvement of Ms. Breitenbach as both committee assistant and FLC chair. She wanted to see the SMS. I mean, it is asking too much. She wanted to see the SMS as the evidence before she go and defend herself to that charge that she gave this instruction about the scoring of Mr. Ibrahim. And those points were taken by her during the initial hearing that took place before Mr. Hans-Juri Moorman, which was between 20 and 22 March. You would see from the papers that what then happened is that one of the issues was whether the panel members, Ms. Kammerer and Mr. Monchusi, should recuse themselves.
Is this relevant to this time?
It is relevant in the sense that the reason why, as we said at the outset, the reason why the DA is elected to invoke the cessation clause is because those disciplinary hearings are basically stalled because of the two demands that Mr. Lille made, which have not. That's why we say in the papers, if the DA is prepared to grant Mr. Lille an open hearing, an open disciplinary hearing, not a secret, private, in-camera one. Number two, if they're prepared to appoint an impartial person, then that whole process could take 1 month, less than that. But from our point of view, we are bound to take these points which have derailed those proceedings for the very reason that the demands on those two basic demands aren't met. The Moorman DC then came to an end basically on the preliminary points at the 22nd of March. We're still waiting for judgment on many of those points. He's decided not to allow us to have an open hearing. But then what happened is that there was a second disciplinary process that was started, which we refer to as the Joubert hearing. on the 22nd, as the Moorman hearing was drawing to a close, my attorney was handed a further charge sheet, you would recall from the papers, to appear before a separate disciplinary a week later.
22nd of March.
22nd of March was the last day of the Moorman hearing. To appear on the 3rd of April before a separate disciplinary hearing on one other charge. Now, it's not clear to us why that wasn't added to the Moorman DC, other than that it's an abusive process, that it was done purely in order to ruin her financially. So the second hearing before Mr. Len Hubert then started on the 3rd of April with one single charge, which in fact, if you look at page 157 of the papers, 157, perhaps we can go there, because at page 157 you'd see the independent investigators, as now Cliff Decker attorneys, Mr. Stansfield and Mr. Singh, you'll see at page 157, paragraph 5.2. This is the finding that has already been made about this. It said, in relation to the comments made in respect of the Executive Mayor during Skipper's evidence in arbitration and the summary reflected in the award, we find no evidence during our investigation that the Executive Mayor played any role in either the shortlisting or subsequent appointments of Board Director. But that's now the charge that we're still facing. And of course for the city it's quite difficult, for the DA it's quite difficult, because it constantly has to get the documents that the city has got from Bowman's, from Cliff Decker and so on, and then it wants to replicate disciplinary charges and hearings in its own processes. So on this one, it is behind the curve.
The document on page 157 commences at 155. It's dated the 18th of April. This is an investigation by attorneys at the request of the city.
Yes. But as we say in the papers, Mr. Bagram is now trying to arrange for us to have this disciplinary continuing. Well, this was at least until the automatic cessation clause. But the charge has already been effectively found to have no merit by the city's own investigators. So what we had was the motion of no confidence in February. We had the Moorman inquiry 20 to 22 March. Then we have the Hubert inquiry about the separate charge in April. And then we find the Congress between 7 and 8 April, where the recall clause was approved. Now, Mr. Buffalo ready for the recall clause, and I'll be brief, because as your Lordship already knows, that clause was sought to be invoked about a week or 8 days after it was adopted on 16 April. Mr. Smith writes, asking for permission for the internal motion of no confidence. The internal motion of no confidence then succeeds 97 to 41, but we mustn't forget about the 15 that absented from voting. So it isn't necessarily only 97-41. But it's clear that the 116 vote, the threshold was never going to be reached. We made representations regarding the implementation of the recall clause on the 2nd of May. Then the weekend follows 4-5 May, in which they sit FedEx for the first time after the Federal Congress. They apparently then decided that because we send draft court papers, they need legal advice. And then ultimately never invokes the recall clause. But on Tuesday morning this week, at 7:52 in the morning, the automatic cessation clause letter is then delivered by email to this level. My Lords, now I would like to elaborate on how the cessation clause works in our submissions, and if I can take you to page 76 of the papers.
We're going on to a new point, perhaps we should take a 10-minute adjournment.
Indeed, this is De Lille versus DA. Facts also citing there that DA leader Musi Maimane saying that it's disappointing that the matter between the DA as well as De Lille had to go to court. Of course, just some of the points that had been mentioned there leading up to this DA court case there from Dali Mpofu, who is representing that of Mayor Patricia de Lille, to request that she be permitted to remain a DA member as well as to continue serving her function as a city mayor of Cape Town. Just hearing both views there coming this morning from the judge in Cape Town. We've been giving you the live press briefing as well as court.
Is it on? Yeah, is it? Oh, okay. Okay. testing for sound. Hi, Shante. I'm just going to... You guys need to come back. Guys, I might... Okay, because they're coming back in 10 minutes, but I won't be on camera. Yeah. Mark, I'm going live now. You don't have to come to me. Just stand there.
Still the first day in the High Court in Cape Town. We've been giving you those live proceedings there this morning. We do have our reporter on the ground, Nomawethu Solwandle, who has been covering us this morning, as well as giving us a prelude before that court briefing this morning. A very good morning to Nomawethu. Just a couple of moments ago, just as the court proceedings had adjourned for that 10-minute break, we saw some supporters chanting, possibly showing their support in the courtroom this morning. Just take us through this morning's highlights.
Well, a very good morning to you, Shante. Like you rightfully said, we're bringing you back to the Western Cape High Court. Earlier, we were outside when proceedings had started, but at the moment we are inside. You are right, we have taken a 10-minute adjournment here, and what you see there are De Lille supporters that have been here for most of the morning. They've been saying hello to her, shouting during this adjournment that they're here to support her, and saw her turning around waving as well. But I must take you through what happened also earlier before court proceedings started. We saw different groups outside of court, Shante, and basically there are people that are anti-Patricia de Lille outside of court, and there are people that are here to support her. And there was almost like a clash this morning between those two groups. Nothing serious, but obviously the battle lines had been drawn, and you can see her there inside of court just talking to some journalists, basically asking how she feels this morning. I unfortunately can't make my way to her at the moment to get that sound, because we are mic'd up and cables are all over the place. As you can imagine, this is a very important story, Shante, so the courtroom is very, very, very packed with journalists. I'm going to have to leave it there. It looks like the judge will be coming back here this morning. But something that I must say, Shante, an announcement that was made by the judge earlier on before things got underway here was that in chambers they had decided that the matter will be listened to on the 25th of May, and that matter will be listened to by 3 judges. So basically what's happening in court this morning is that the different legal counsels will go through the points that they will be deliberating or debating on the 25th of May. So it's just to get the ball rolling and to understand what we're sitting here for, but the matter will be listened to on the 25th of May. Shante, back to you.
Thank you very much for that. Nomawethu Solwandle for SABC News in Cape Town, just giving us a briefing as well as what essentially today's court proceedings have already taken place, and also what we can expect. They're also confirming on the 25th of May that 3 legal counsels or judges will be listening to the matter, and also just taking us through some of the highlights that brought this matter to court. We do know that the DA rescinded membership of Patricia de Lille last week. During that press briefing that was delivered, they cited one of the reasonings for the recall or cessation of de Lille's membership was due to a constitutional clause within the DA saying that she had publicly announced that she would be leaving the DA, and that was also brought in court this morning. That radio interview in question was also brought to the fore, as well as the request there to actually have the transcript between that radio interview. Well, we will be giving you more updates. We do know that the court proceedings are set to get underway in the next couple of moments. They are set to get underway in the next couple of moments. Apologies. And as soon as they do start, then we will cross back to those live proceedings in Cape Town in the Western Cape High Court.
That I supposedly sent regarding Mr. Ibrahim when he applied for them. Blatant buckets, Glennis blatant buckets. He refuses to provide it. My issue was argued on the 22nd of March 2018. And it's unclear to me why one panel has not delivered this. Because my lawyer said, okay, this is the charge of your client. You bring the press. Sorry?
Yeah, exactly. Hello. I thought the judge comes. Yes. Hello, how are you? Yes, when the judge walks in, then judge done. How is it a victim?
It must be around.
Are you done it?
Alles good. How's it?
All right, thanks.
I was trying to TV you. Okay. Paying you on time. No, after doing some work with the I think the work in January.
That's what's the problem when you're freelancing. They just don't think you need to. People ask me, do you speak Chinese? I'm like, no, I just don't speak You're freelancer, then? What issue with them?
It is May now, really.
I'm not naming anybody. There's always a thing with that. So now we don't you should be getting paid. Our part is done. That's the first thing. But I'm not talking about CGT, I'm talking about over the years I've worked with other people. Always.
Yes, Mr. Temple.
Yes, just a quick report back on the discussion regarding the May Court.
Regarding?
The May Court. The court has asked us to we haven't had such a discussion, which Madam trying to confirm. There are instructions that have been taken by the other side, and we have also received. This stage, it doesn't look like there's anything that will affect the hearing.
Sorry, it doesn't look like what?
That there's anything that will affect us going ahead. In other words, what I'm suggesting is while those instructions are being taken, we carry on with the hearing. I'm not optimistic that it's going to lead to anything, speaking for myself.
Yes, I did see in the papers that One of the ideas that was exchanged between the parties was that the applicant might take special leave or something like that, while the deputy mayor stood in as acting mayor, and that the extant maker would continue. Was that a suggestion that came from the applicant's side or from the respondent's side? I read it somewhere in the papers.
Well, it came from both sides. In short, the overture for any solution would come from the respondents, and this was in a way kind of a response there too. So, even those discussions had come to nothing, which is why we're here.
But are you informing us now that, given the position of the maker, that the argument that is raised by the DA around balance of convenience and the irreparable harm that may be suffered if maker has to change backwards and forwards, that's no longer does no longer appear to be an issue?
Yes, absolutely. It's something obviously subject to argument. It cuts both ways. From our side, we're going to say, well, 2 weeks, balance of convenience for 2 weeks, why not? And I suppose Mr. Rosenberg will have something else to say about it.
Thank you, Mr.
Lord, can I take you to page 76? We're dealing with a cessation.
We're over your notion in lots of time, so I'm going to keep you on a tight leash if I may. And ask you to focus on the core issues. We do need to finish this matter today. Okay?
Lord, if I can take you to page 77 then, to the automatic cessation clause that starts at page 76. It says a member ceases to be a member of a party when he or she, and the relevant one is 3.5.1.2, publicly declares his or her intention to resign and /or publicly declares his or her resignation from the party. This is the clause that was applied to Mr. Lille, and the case concerns the meaning and application of that clause and whether it's constitutional. One of the points made by the party is that it's a very simple determination. All the matters in 3.5.1 are really matters which are simple, easily to establish factions. Now that is not the case. This clause, if you go through it, contains all sorts of ways in which...
Sorry, I need to stop you there. We're going to run into trouble if we start talking about constitutional. So you're going to have to distinguish between the DA's constitution and the national constitution. You say that this is in conflict with the Bill of Rights?
Yes. Section 19.3, Section 16. But my Lord, for the moment, the point is that none of these clauses, or very few of them, are capable of easy determination as to whether conduct falls within those clauses. Because if you, for example, look at 3.5.1.9, after being warned to desist, publicly and unreasonably disparages the party or decisions taken by its structures. So there's a lot of these clauses. 3.5.1.10 is the implementation of the recall clause. 3.5.1.13 is if you support a motion of no confidence in your own mayor, then you automatically cease to be a member, and so on. So what we say, and what Mr. Lille says at page 279 of the replying papers, none of these clauses have ever been invoked against any member but a public representative that the DA wanted to get rid of.
Mr. Duval, 3513, the cessation clause, you call it?
3.5.1.3.
Yes, the cessation clause. At page 77?
Yes.
You've termed it the cessation clause as opposed to the recall clause.
3.5.1.2, my lords, is the one applied to us.
Sorry.
She says...
Just a moment, please. Has that been in the DA constitution for an appreciable period of time?
My Lord, at least these clauses have been there at least since the decision of the Supreme Court of Appeal, those two at least, that we attached to the replying affidavit. So So that was in 2008 decision. Well, the High Court decision number is 2008, because you'll see a reference to them there. They've grown, my lord, because we know that 3.5.1.10 has been inserted now at this last Congress.
Do we know from the papers when the applicant joined the party?
Lord, I would have thought it's 2007. Yes.
So the clause,
you can take judicial notice
there
of
when she joined the party.
Sorry, no?
That clause was in the Constitution when she joined the party.
I wouldn't know that, my lord. I would have thought so. So, my lord, she joined in 2010, I'm told. My lord, at page 279, as we say, these clauses, and we'll refer to other examples as well, where they're not invoked and when they're selectively employed to target dissidents in the party. Public representatives, particularly when that public representative holds a balance of power and can cross the floor to another party, so the control is given away over a council. They're not used in another context. Our submission is about 3.5.1.2.
So why are you very straight to that article that depicts, for example, the DA leader,
yes.
Mr. Maimane,
yes.
who said something similar?
Yes. Quite.
Yes.
Maybe just summarize our submission. Of course, these will be developed in the Part B. About 3.5.1.2. It is facially unconstitutional and inconsistent with Section 19.3, and particularly the right to be elected to office and to hold office. Because we say it's implicit in that right, the right to hold public office, that you cannot be removed from public office without some good reason. This clause, we submit, is too vague and capable of being abused. And accordingly, it is inconsistent with Section 19.3. Because, let's take a few examples, if I may use just two.
I'd like to hear you sooner or later, I don't know whether it's you or Mr. Koff who's going to deal with it, and what the prima facie right is that you rely on at this stage for interim relief. I know that these are all issues that are going to be dealt with in 2 weeks' time, but I need to have focus on what the prima facie right is upon which you rely, because there's an attack in the heads of argument on behalf of the DA that your affidavit is light in the prima facie right. So I don't know whether you're dealing with it or whether Mr. Koff is dealing with it, but we would like to hear you on that soon.
It's on the three headings, my lord. Our prima facie right is, of course, determined by how strong we will be in the review in 2 weeks' time. Our prima facie right to the interim relief depends on whether we identify reviewable irregularities and whether we will succeed in 2 weeks' time. What are the prospects of us being successful 2 weeks from now? That is how the strength of our prima facie right must be determined. Now, firstly, what we've already done is we have attacked in our notice of motion this clause facially, because we say it's vague, it's overbroad, it's capable of being abused, and it's inconsistent with Section 19.3. What if someone says, I will resign from the DA when I reach 70 years old? What then? Must you now immediately lose your membership? What if someone says, I'll resign from the party unless diversity? I'll resign from the party unless women get equal treatment. What about those statements? Because the way the DA wants to interpret this is not that it causes harm. Not that you say you are declaring in public the intention to resign in a manner that causes the party harm. And that's why I read to your lordships 3.5.1.9, because there at least it says unreasonably. They want to interpret it to mean anything, any public declaration.
I understand the argument colleague will speak for himself. I understand the argument that this is one of the legs of the attack which the full bench will hear.
Yes, right.
I'm trying to understand what the prima facie right is that you rely upon now
My Lord,
for interim review. There may be a difference between the two.
My Lord, if the decision was bad, because the clause is bad and unconstitutional, then of course I've got a prima facie right to the relief. In every tender case, in every review, the question is always, will he be successful ultimately to have the tender award set aside? Will he be able to get the liquor license in the end? So the question is, will we be successful in the review in 2 weeks' time with our argument that this clause is unconstitutional?
Well, do you have to go as far as that? Is it not, is the test not a prima facie right though open to some doubt?
Yes, quite.
Well, then you don't have to persuade me that the point is anything more than arguable.
Yes, arguable. So, my Lord, our other points in my Justice Abela has already raised it. How are these clauses applied? And that's why we attach those examples from page 286 and onwards. What does Mr. Maimani say on 15 July 2016? I will resign if the DA doesn't deliver. Now again, what will be argued is, in 2 weeks' time, is, oh, but you've got to understand, this statement, the context indicates that he's saying, I'll resign as leader. But when we made that same argument, that the context clearly indicated that Mr. Lille meant I will resign as executive mayor, not as member, then said, oh no, you just look at the words. He says here, I will resign if the DA doesn't deliver. Kola Barna, 2 pages forward. If I need to be, I will resign. She says, if need to be, I'll resign. It's a conditional intention to resign. Why not apply it to that situation? 1 page further, Ms. Mubenya is in fact, in 2016, according to this press article, resigned in fact. The shock resignation of DA's Eastern Cape Provincial Chairwoman, Beliswa Mubenya, sent the party into a tailspin. Now they're all running towards her, according to the article, and say, please withdraw your resignation. Maimani and Zilla was locked in a meeting in a bid to come up with strategies to convince Mubenya not to leave.
So your argument is to the extent that there's procedural fairness that applies to the termination of membership, there's an inconsistent application of that principle.
Yes, indeed.
And that you say might afford you a prima facie right on review as well.
And if your Lordship look at the clearest example is actually the SCA in the judgment of theirs dealing with this Jones. Because your Lordships will see there, it is recorded at paragraph 2 at page 294 of the judgment that his post became vacant consequence to his resignation from the municipality and as a member of the DA. And as a member of the DA. This is what happened. But of course, after that, and in this particular instance, in George, it would have affected the balance of power. And you'll see then, as you read forward, Mr. Lont then came to him and persuaded him, after he gave the ANC a letter of resignation, which they sent on to the IEC. Then Mr. Lont said, please withdraw your resignation. And ultimately, that was done. And the case was then about whether his position became vacant. So, my Lord, we can go on with example after example, but the problem is that if you interpret it in the strict manner that the DA has proposed, doesn't matter whether it's conditional, doesn't matter that there's no subject intent, doesn't matter that it's later withdrawn. If those are if that was the basis upon, context doesn't matter. If all of that is the case, then we would submit that the clause is facially overbroad and unconstitutional. That's our first point. If I may then go on to the second aspect, which is the procedural fairness of it all. Your Lordship would see at page 78, paragraph 3.5.3. The process or processes to be followed in the case of cessation under this section will be determined by the rules of the Federal Legal Commission, page 78, paragraph 3.5.3. So how this is to be implemented, how they deal with, for instance, the argument that Mr. Lowell lost the membership because of the public declaration of intention to resign, is to be determined by rules of the FLC. Those are to be found at page 120 and onwards. And if I can take your lordships there and briefly explain our procedural points then, or as Mr. Paul has put them, the non-compliance issues. From page 121, these rules for cessation of membership are set out. Now, we've got arguments that are set out in our papers on each of these. Paragraph 2, 3, 4, 5, and I'll briefly list them. Paragraph 2 at page 121. What should happen is, as soon as the relevant federal executive receives prima facie evidence which indicates that the public representative's membership has ceased, this must then be referred to the chairperson of the FLC. So it says federal executive refers it. But Mr. South, we know, in fact, took the decision. He claims he's done so under delegated power, and your lordships will find the delegation at page 257. That delegation apparently was done in 2002 and reiterated in 2011. Our argument is a simple one. The FedEx is reconstituted every 3 years.
There's an ultra-virus point on this. There's an ultra-virus challenge on this paper. That's all we need to know.
Then, paragraph 5 over the page, 122. Paragraph 5 on page 122. What you can see how this works is that they present a letter of cessation describing the basis upon which it's alleged that one's membership ceased. And then you have 24 hours after having been served with such a letter to provide the chairperson of the FLC with clear and unequivocal written reasons why his membership did not cease. So there are two things. You've got 24 hours. You can't provide an explanation. You have to give clear and unequivocal reasons, written reasons why membership has not ceased. Not just cast a doubt. Clear and unequivocally, you must persuade them for those reasons. Now, the only question is whether this clause, which we attack, is consistent with the rules of natural justice. Because you will see from page 107, if I can take you there very briefly, page 107, it's stated that the party's rules, or the FLC rules, is subject to the Constitution. And by page 107, it says at 10.5.1, the rules of procedure prescribed by the FLC must apply to all proceedings of a panel, provided that the rules of natural justice must at all times be adhered to. Now, if you just turn 2 pages back at 105, one sees there at 10.1.4, the FLC may determine rules of procedure, but they may not be in conflict with the Constitution. So our argument is a very simple one.
Just a moment. Paragraph you said from 10.5.1 you go back to that?
Yes, back to page 105, my Lord, at clause 10.1.4. The rules of procedure of the FLC may not be in conflict with the Constitution. The question
is the DA Constitution.
Yeah, that's the DA. Yeah. So in terms of the rules that the FLC made, not in the Constitution, you've got 24 hours to provide clear and unequivocal reasons. The Constitution, however, requires rules of natural justice to be adhered to at all times. Is that in accordance with rules of natural justice, 24 hours, and placing that burden, which is referred to by the panel themselves as a heavy burden, with further presumptions also in clause 3 about what shall constitute sufficient proof of such a public declaration. Is that in accordance with the rules of natural justice? It's not difficult to decide that, my Lord, because the issue has already been raised in the Matheson case that Your Lordship haven't handed up our bundles, but if I can refer you to one passage of this.
All right, a fascinating legal battle going on there in that ongoing dispute between the Democratic Alliance and Patricia de Lille. The tension certainly within the DA caucus just continuing to spiral, but we've been hearing from both counsel for de Lille, Advocate Dali Mpofu and Advocate Johan de Waal. They've been talking about the DA's accountability clause and essentially de Lille's request to remain a DA member and to continue serving as Cape Town Mayor. But we'll get a bit more for you on this. Our Nomawethu Sowandle is there. She'll unpack this a bit more for us. In the meantime, we'll take a quick break. I'll be back after this break with your headlines.
And will comply with all requirements and conditions of such notice. And then the important one, failure to do so will lead to the member's immediate expulsion and dismissal. So what happens is they suspend you, they impose conditions of suspension. If you don't comply with them, automatic expulsion. And Goliath Jagan explains in paragraph 26 how it works. And I'm paused here for a moment because my learned friends in their head say this case is not dealing with an automatic expulsion. This is why I pause a little bit longer on this. Paragraph 26. First respondent argues that acted within the parameters of its disciplinary code. The applicant was instructed to withdraw his request for a special council meeting and motion of no confidence by 5 o'clock on 12 October, which he failed to do. The applicant was then suspended on conditions that he should withdraw the request by 5 o'clock on 13 October, which he failed to do. Hence is it argued that in accordance with Rule 2.16, if the member violates his suspension conditions, he loses his membership of the ACDP automatically by operation of law and without any further decision. It's the same argument as the DA is making in this case. He was fully aware, as indicated in the letter of 11 October, that he would automatically lose his membership if he failed to comply with the suspension conditions. And it goes on. The ACDP therefore argues that on the applicant's own version, he automatically lost his membership at 5 o'clock on 13 October 2012. It's by operation of law. There's no reviewable decision. All the arguments you'll see at their heads. Now, the question here is, was there procedural fairness? This is what Goliath J envisages or has to deal with, because if the Lordship go one page further, page 62, paragraph 28, she says in the last sentence, I am in agreement with the applicant that the period of 48 hours given to him to respond to all the issues raised in the suspension notice was unreasonable. Applicant was not given sufficient time to prepare and present his case to avoid possible expulsion. Over the page as well, at page 63, paragraph 30, the last sentence. Not only was the applicant given insufficient time, now we're talking about 48 hours, not 24, without any presumptions, without any burden. Not only was the applicant given insufficient time to deal with all the issues in the suspension letter, but also the manner in which he was expelled was unfair, unreasonable, and not consonant with the principles of natural justice. Why? Because it was too short. It must be borne in mind that the termination of his membership was a drastic measure which would effectively deprive him of his seat and his income as counsel. Now, we say that the present situation is unlawful. She interprets the rules of natural justice and finds that a period of 48 hours is too short, given that one would lose your position as counsel. So there's every possibility that in 2 weeks' time, clause 5, designed or adopted by the FLC, will be found to be invalid because it is inconsistent with the rules of natural justice entrenched in the DA's own constitution. Paragraph 6.
Paragraph 6 where?
Paragraph 6 of page 122. I'm moving on to another point here. Was the panel that considered Mr. Lille's, and I'll be a bit longer on this one also, because here, with great respect to my learned friends, I cannot see how in 2 weeks' time they will get around this point, because it is the third time that I'm arguing this point, so it was argued before the Moorman panel and before the Uber panel as well. Paragraph 6, what does it say? The chairperson of the FLC must as soon as possible after receipt of the written reasons, this is now of Mr. Lille, presented to a panel of the FLC. So it's presented to a panel, and our argument is that the panels have never been properly constituted due to the manner in which they were originally.
So do you accept that it was presented to a panel, in the present case it was presented to a panel, but you take issue with the constitution of that panel?
None of the FLC panels were originally properly appointed. And our argument here, if I can take your lordship to page 305, which was the provision of the DA's constitution which applied at the time when all these panels were appointed. Page 305, Lord. Just pause for a moment. It is one of the reasons why we say those disciplinary hearings against Mr. Lille has stalled. Because when we raised this argument, it meant that those panels were all improperly appointed. Clause 11.1.1 says this: FedEx must, at its first ordinary meeting after each Federal Congress, elect the chair and the deputy chair of the FLC. We know who they are. It's Mr. Horn and Mr. Aiken. Those are two that they do. Thereafter, the FedEx shall appoint a panel of 10 additional people who are as objective as possible, preferably including one from each province. So FedEx then appoints another 10. Then these 12, who together with the chairperson of the FLC will make recommendations to the Federal Council for the appointment of the other panel members. So one gets the first 12, and they then make recommendations for the appointment of the other panel members until you have up to 20 plus 10 alternatives. What have they done? Your Lordships will find what they did at page 173 with the appointment of these panels. At page 173, paragraph 14.2. Lordship's got that?
Yes.
They refer to clause 11.1.1. But then it's recorded as follows. Historically, this panel had consisted of the 9 provincial leaders and himself being the leader the chair of FedEx. You'll see from the top, chairperson said. Historically, it consisted of the 9 provincial leaders and the FedEx chair himself. The leader indicated that they wished to be part of the panel. FedEx agreed to this proposal. So in the end, they thought that the panel envisaged by 11.1.1 that must select the other panel members can consist of 9 provincial leaders, Mr. Self, Mr. Maimani, and this panel then went to go and appoint all of the panels. And you'll find that 2 pages on, at page 176. The panel had, by means of a telephone conference, and had considered all the nominations carefully, taking into account geographical spread, so on. Following panel members were recommended to the Federal Council. So instead of FedEx, page 176, my lord. Sorry, I'm going. So instead of FedEx appointing the first 12, it had just constituted these provincial leaders, Mr. Self and Mr. Maimani, and then went to go and appoint all 20, which is clearly inconsistent with this. Now, we know that the Constitution is subsequently being amended. The new Constitution has been amended, but the panel that considered my client's representations had to be constituted in terms of this old procedure. Now, your lordships may find...
When did the procedure change? At the most recent National Congress?
Yes. Now, your lordships may find this argument technical, and it's for this reason that we refer to your lordship in our bundle. I'd like to refer your lordship in our bundle to the Crocombe decision, because, and it's in our heads of argument as well, because that argument was, if I may just find the reference to it in our bundle, and yeah, it starts at page 22 in our bundle. And the relevant passage being page 22.8, A, capital A, 28, capital A. So it is a technical point for some, saying that the panel wasn't properly constituted. What does the SCA say about this kind of argument? Page 22, capital A. It's common course that the civic as a political party, paragraph 16, is governed by its constitution, which represents the collective voice of its members. This constitution spells out clearly when and how members of the civics NEC will be appointed and removed from office. It follows, therefore, that the NEC is constrained to exercise only those powers entrusted to them by the Constitution, and strictly in terms of the Constitution. This is in line with the principle of legality. Any conduct that falls outside the purview of the Constitution is therefore ultra vires and invalid. And then they go on to say, I've already indicated that as to May 2012, Daemons had not been elected onto the NEC as its member in terms of the Civics Constitution. He was only co-opted thereafter. So there was a similar point in that Mr. Daemons was taking part in an NEC meeting some 26 days before he was co-opted onto that NEC. And the SCA says, well, he wasn't properly there on the 2nd of May. He was only co-opted 26 days later. And that's why it's ultimately found. He therefore had no right to participate in the NEC's meeting qua NEC member. He was essentially a so-called stranger. And all the actions later, all those meetings, everything that happened there is set aside. Now, similar, one can just take Mr. Maimane. He had no right to be part of the decision to appoint the panel. The whole manner in which the panel's 20 members and 10 alternates were selected was accordingly invalid. So this is one step in the middle of the FLC procedure, which then, one cock in the wheel, which then falls away, and the decision was formed. But there are others as well, and we've listed them, and I'll go back to our heads now just to remind your Lordship where to find them. Paragraph 9. Ultimately then, after the FLC makes a recommendation, FedEx then has the power to confirm the determination of the cessation of membership of the affected member. And the question is, does it then exercise a discretion? Sorry, my Lords, at page 122, paragraph 9. So the FLC panel, which is improperly constituted, makes a recommendation to the federal executive, who then may confirm that recommendation. This introduces, of course, a discretion, which triggers our boni vire point, but also, how should that discretion be exercised? And there's a provision of the DA's constitution that I remind you that this rule cannot be inconsistent with, which requires that the member must be able to put up mitigating circumstances. And your Lordships will find that rule 10.5.1, page 107 again. She must be given an opportunity to submit evidence of mitigating factors. Now, that can only be done after a conviction of a kind, and FedEx should then have given her an opportunity. Paragraph 10.5.1.2 at page 107. Now, finally, at page 78, my leader just reminds me, the final point being at page 78, that the Constitution requires that the provincial authority refer the matter, page 78, paragraph 3.6.2. If the membership of a public representative is terminated in terms of section 10.12, or if a public representative ceases to be a member of the party by virtue of 3.5.1, the relevant provincial managing director must notify the relevant authorities of the vacancy. Now again, it's not complied with, common cause, because at 150, you'll see that Mr. Self took on the responsibility again.
What is the consequence of that?
The referral, the notification is invalid, no vacancy arises. You can say that the party's procedure up to that point was fine, but how does the decision get to the city, the relevant authority in this case? It has to be done by the provincial managing director, not Mr. Self. Again, you can say these points are technical, but if I can take you back to the heads of argument, just at the final decision of the Constitutional Court in a case that Mr. Mapofu was involved in, the Ramakatse decision. Perhaps I can just read the passage to you from the heads of argument, because I am going to go to the heads of argument now, my lords. At page 12 of our heads, and I'll just go through the various the basis upon which we find prima facie right in the heads of argument. At page 12, what does Ramakatse, what's the Constitutional Court say there?
What paragraph in the chapter?
Sorry, it's paragraph.
All right, we're taking you out of that. We do apologize for the poor sound coming from that feed, but just to recap again for you, hearing from Advocate Johan de Waal for De Lille as that contestation around De Lille's DA membership and her mayoralship continues. We'll have more on this coming up for you in our news at 1. Let's take
Construction. I would hold that the right to participate in activities of a political party confers on every political party the duty to act lawfully and in accordance with its own constitution. Now the important part, this means that our constitution gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership. So as Crowcombe says, we're looking for strict compliance. Ramakatse say you've got the right to exact compliance. My Lords, may I just then list our points? I won't make submissions on them now because they summarize them here on the prima facie right from page 12. Paragraph 20.1. This is our authority point. Sorry, my Lord?
Are these now in your heads?
Yes, my heads. But I've dealt with them and I'll just list them and refer your Lordship back to what I said. Paragraph 20.1. This is the point that we made that Mr. South did the referral and not FedEx and that his delegation was invalid. That's in paragraph 20.1. Paragraph 20.2 over the page 13. There's a point that I didn't deal with, but Mr. South, in fact, never referred the complaint from Mr. Kopane about 3.55.1. He asked for the FLC's advice. He didn't refer the matter. Your Lordship will see at page 126. He asked for the FLC's advice on the complaint and not refer it for determination. Paragraph 20.3 is the unlawful constitution of the panel. Paragraph 20.4 over the page is what I've just dealt with now, which is the fact that Mr. Self referred or communicated the outcome of the process to the city manager instead of the relevant provincial manager. Then the procedural fairness points that paragraph 21 and forwards, the first one being that to the extent that one can superimpose PAJA on this contractual relationship, much like your Lordship did in the Parkscape matter.
Is that still good law at the moment, Mr. Lord?
Lord, I don't know where that appeal is, but the argument is the argument on behalf of the applicant that PAJA does apply? Alongside the contract, yes. I know that there are decisions, but the decision of Acting Justice Lansing says that PAJA doesn't apply to this, but there are, as the SCA summarizes there, varying responses, and no final decision has ever been taken that PAJA cannot apply alongside the contractual relationship between member and party. Lords, I'm told that the Constitutional Court left it open in Ramakatse as to whether PAJA applies to this.
So this is one of the further points that you intend to advance by way of...
Paragraph 20 over the page 15, paragraph 21.2. That point I've already argued now. This is that clause, the FLC rules are inconsistent with the rules of natural justice, which is entrenched. 21.3 I haven't really argued. up till now, but it is the argument that the FLC rules is also contrary to public policy, as it allows determination of a public representative's position without due process being followed. And public policy in this context, if we can hand up the Bredenkamp decision of the SCA, and I'm not going to take your lordships there, but just refer you to Bredenkamp at paragraph 43, where the court, the SCA finds that public policy, the question of whether a contract is contrary to public policy, must be determined in light of the values of the Constitution. And we intend to argue that these FLC rules and clause 3.5.1.2 is inconsistent with public policy because it undermines section 19.3 of the Constitution. Paragraph 43 of Bredenkamp is authority that one looks at public policy and determines whether
through the prism of the Bill of Rights.
Yes.
That's the constitutional court. In Barclays and versus Lake.
Paragraph 43 of Bredenkamp interprets and captures what Barclayson, according to his Lordship Mr. Justice Harams, means in effect. That it's not this unruly horse. Anybody can say this contract is unfair and therefore it's against public policy. You've got to identify a particular provision of the Constitution, the Bill of Rights, which you say informs public policy, which the contract is inconsistent with. At page 15, paragraph 22, we deal with the Matesi judgment that I've already done. Then our substantive unfairness points are listed at page 16. And I've dealt with the first one already, which is that the clause is inconsistent with section 19.3, as well, of course, as the right to reasonable administrative action if PAJA applies. And we also say that the discretion was not exercised boni vire, and the rest of these submissions will then be dealt with by Mr. Mpofu. Those would be the part that I would do.
Thank you, Mr. Mpofu. Wrapping up, as it were? Wrapping up an hour into injury time.
Well,
sorry.
What I just want to contextualize first, very in 2 or 3 sentences, the reason why.
Just a moment, please. There's a technical problem.
Yes.
Thank you.
I just wanted to contextualize why the material that Malaysia and Mr. Deval have to deal with, how it fits in with what I'm going to say. Effectively, what we're saying is give the historical account in order to explain, as I said earlier, why this unlawful conduct was resorted to by the DA. But more importantly, the issue about what one might call the jurisdictional facts or technical non-compliance with its own constitution by the DA. As Malaya said, might sound technical, but at this stage of the proceedings, this is what it does. It simply says to this court, prima facie, to be resolved in 2 weeks, it would seem that the so-called cessation clause was not correctly applied. In other words, if you jump all sorts of technicalities, what that really means is that Ms. De Lille is, as we speak, still a member of the DA, or if you want to be technical, you can say will be proved in 2 weeks' time to have been a member at this point today as we speak. Now, the importance of that is central to this interim application, because you're going to hear for a long time that, but she's not a member. And because she's not a member, remember that is just the farce that is used. Not really because they're worried about the membership list of the DA. It's got nothing to do with that. What they really want is to remove her as a mayor. So the so-called cessation of membership is just a stepping stone towards what they really want to achieve, which is to take her out as a councillor and as a mayor. So once the edifice of the first stepping stone is removed, then what are we doing here? So the importance of what my friend Mr. Duval is saying is that if it can be shown, let's take any example. If it can be shown, for example, that at a particular point where she was entitled to Audi, that Audi was not granted. If it will be shown that the so-called panel was not properly constituted. If it can be shown that James Self didn't have the power to refer the matter to the council, a very important one. Ironically, the one that looks even more technical is the most crucial. Because remember, the first is that there's a vacancy, there's an acting mayor and all that. But let's just, for a minute, my lords, assume that this court will find that the referral of the vacancy to the city council, because this is now where the interface between the party and the council is, was defective. Boom. Then it's all gone. Then what we have is just smoke and mirrors, but in actual fact, Ms. De Lille is still a member of the DA, is still a councillor, and she's still the mayor. So that material is important for that reason. But it's important for a second reason, which is what Justice Gamble was asking about. How does that then link to the question of the prima facie right? And again, we don't have to debate now whether PAJA applies and so on. Let's assume PAJA doesn't apply. Let's assume that all we have is merely the contractual rights between the member and his party, where Rabakata makes it very clear in the Constitutional Court that the relationship between a party and its member is the same as the old Jockey Club cases that the court will be familiar about, wherein it is said that a breach of that constitution is the same as a breach of a contract. In other words, that relationship is contractual. So even if you left it at that level, forget about fancy arguments about PAJA, which will be dealt with in due course. Then even at that level, there would have been prima facie expectation on her part, at the very least, of how the act rampart and whatever has been identified. For example, yes. So that's the connection between those submissions.
Do I understand you well, Mr. Mpofu, that what you're saying is that the procedural unfairness of the applicant resulted in her having this prima facie right.
Absolutely.
But then it will be again argued at a greater length in Part B.
Yes.
But presently, on account of this procedural unfairness, this has resulted in her having.
Absolutely. And as the court uses, and my lord, this ties up with what Justice Gamble was saying. Remember, at this stage, all we have to do is to show that those rights, procedural rights, as your lordship call them, are prima facie existent. The fact that in 2 weeks' time on closer scrutiny, you might find that, no, the comma should have been there and so on. That's irrelevant for the purposes of this court. All the court has to say is that there is a right open to some doubt, even. In my respectful submission, it's not these rights that have been elucidated here are not open to any doubt, but put that aside. This court has to determine that there are those rights, and therefore, that's what I'm saying, the crucial thing about it is that, and therefore, if those rights are found to exist in 2 weeks' time, it's not going to mean that Ms. De Lille is a member in 2 weeks' time. It will mean that she's a member now, as we speak, of the DA. That's what this kind of relief is meant to do. It is meant to assist those parties who cannot wait for 2 weeks or 2 months or 6 months in most cases for the determination of their rights, so that we arrest the situation as it is now and grant relief based on that.
What about prejudice? Would then the applicant be prejudiced if she is not reinstated within these 2 weeks?
Yes.
And perhaps balancing it with then the prejudice.
The Lordship is quite correct. In fact, that question goes directly to the 4th requirement, which is the balance of convenience. And as we say in our heads, the balance of convenience is an easy test, which is usually misapplied. It's all that the balance of convenience test says is we must look at 2 scenarios. If she is unsuccessful in 2 weeks' time, let's assume that court finds, no, she was never a DA member. Her membership expired on the 26th of April. What inconvenience would the DA have suffered in that period? And then you have to flip it on the other side and say, if she is successful in 2 weeks' time, and she has been removed for the 2 weeks, what inconvenience would she have suffered in that period? Which is the question I'm about to answer. Subject to this, unfortunately I don't have the authority here, but it's probably true that in a case such as this one, where clearly the interests of the public are concerned, one doesn't look at the balance of convenience narrowly as just these parties here. Remember, when we say the applicant, we're talking about Ms. Patricia de Lille, Councillor, Mayor of Cape Town. So the inconvenience, just picture this. Let's assume now there's a so-called acting mayor. And for a minute, let's say there was the maker, we know that it's not there. And all sorts of things that we might not know about that then happen from the fact that she has been unlawfully removed. And then, the citizens of Cape Town are also left in this limbo, where actually there's no maker in existence as I'm standing now, where it's not clear who's the mayor, who's going to be the mayor, and so on and so on. Where she is kicked out basically and left out to dry in the open, and even in the court of public opinion. All those things, in 2 weeks' time, we find, oh, sorry, no, we were wrong. Actually, you were falsely dismissed or terminated membership. That's what the court has to weigh. And the court, surely, in a case like this, has to say, firstly, what possible inconvenience can the DA, not the city, not the people of Cape Town, the DA, the political party, what conceivable inconvenience can they suffer if she is there for the next 2 weeks? 0. Versus the multitudinal inconvenience, prejudice, and all sorts of things that will befall her and the people of Cape Town if this situation is left to linger longer. So, and then of course, going back to what my learned friend was saying, the linkage between the practical issues and the Constitution. Remember, it's paragraph 16, by the way, in Ramakatsa. That's paragraph 16 of the Ramakatsa is on page. Yes, page 32 of the bundle. I'm sorry.
Sorry, you were at Ramakatsa,
Yes,
paragraph
yes.
16.
Yes, madam. I was just saying that's the passage that my learned friend referred to. And I couldn't find the passage. Because it's already read it, I'll just read the first sentence. It says, I do not think that the Constitution, meaning now the Constitution of the country, could have contemplated political parties could act unlawfully. Again, assume that all this will be developed in 2 weeks' time. But let's look at what Mr. Duval has said. If what Mr. Duval has said is true, then the party has acted unlawfully, even in the narrow sense of not complying with its own constitution. Let alone the fact that in Ramakatsa, I think it's paragraph 74, the broader statement is made, which again will be developed in the next leg of this case, where Musanaka DCJ says, again I'll just read the first sentence. It bears repeating, it's on page 38, I'm sorry. It bears repeating that political parties may not adopt constitutions which are inconsistent with Section 19 of the Constitution of the country. So, remember that the attack on the Constitution of the DA, or on the relevant clause at least, 2.5.1.12, 2, is going to be premised on that basis. That if our argument is going to be like this in 2 weeks' time, any clause in the DA Constitution that seeks to undermine all our fundamental rights as citizens to join a political party of our choice, in terms of Section 19(2)(b) of the Constitution of the Republic. And that may compromise our right to be elected into office and to hold such political office in terms of Section 19(3)(b) of the Constitution of the Republic. Any clause that may undermine those two